Clive.
Hello, Colin.
Can I say this is the first of what we hope will be a series of podcasts. We haven't given it a title yet. I was thinking a working title. How about the Colin and Clive Show?
Well, I think we're calling it the Legal Eagle podcast, but as we like to call it, the Colin and Clive Show. So welcome, listeners, to the brand new Colin and Clive Show. What have you got for us today, Colin?
I thought today's topic would be inside out. How long will he, they, she actually serve? Yeah. Because it's all change, isn't it? Yet again, with the 50% going down to 40%. And would you believe from June 2025 onwards, the maximum benefit you'll be able to achieve from early release under the home detention curfew scheme is going up from 6 months to a whopping 12 months.
Yeah, as you mentioned, Colin, lots going on, isn't there? The prisons are rather full at the moment, and indeed the last government and indeed this new government have had to take action, and most of that action has come in the shape of home detention and curfew, isn't it? Letting people effectively serve their sentence at home rather than in prison.
Yeah, and I think that's going to be a trend for the future. I think we're going to get more community-based penalties. The requirements of the community sentence will be just that much more harsher. And we're also, I think, going to get more suspended sentences. I think surveys have already shown that people subject to harsh community sentences and people subject to custodial sentences that have been suspended tend not to reoffend quite so often as those who've had an immediate custodial sentence imposed upon them.
The way the wind's blowing, we're yet to receive the Gauck report, aren't we? David Gauck, former Lord Chancellor, has been entrusted by the Labour government to carry out a review. I think they've been travelling around the world to prisons in Texas and other places, haven't they, to see what's going on there and to see what they can recommend. But certainly, in the last 20 years or so, we've seen an increase in sentencing generally, haven't we, Colin, in terms of how long people go to prison for. And I think we're one of the probably one of the harshest countries in Europe, aren't we, in terms of sending people to prison for long periods of time. And I think governments are realising they can't simply build their way out of this crisis by building more prisons or prison places, that something more fundamental needs to happen.
As a society, we've got to make a decision, haven't we? We've got to say to ourselves, which offenders can we actually live with in the community? And my view has always been, I've been in the law now for more than 40 years. My view has always been, I'll live side by side with most people in the community, but do please protect me from those who might want to injure me in some way, or those offenders who commit perhaps sexual offences.
I agree. Preventing future harm and public safety has got to be the first priority, isn't it, of any government in relation to sentencing.
So forgive me, Clyde, I'm going to start off with a bit of a history lesson because this all used to be so simple.
Yep.
So simple. Brief history lesson, if I may. Once upon a time, offenders who were given a sentence of 12 months or less, or 12 months or fewer, effectively anyone sentenced in the magistrate court, where the maximum has always been capped at 12 months. We called these people short-term prisoners because they'd been given a sentence of 12 months or less. The benefit of being a short-term prisoner was that you did your half inside and then you were released. You were not subject to any license conditions or anything of that nature. You simply did your half and out your way. It was different for those people who'd been given a custodial sentence of more than 12 months. Those people were required to do half of their sentence inside and to be licensed for the remaining half. Yeah, quite a simple system if you think about it, a system that most people could get their heads around. Would you not agree?
Yes, and just to be clear, what that licence period means is that if you breach any of your licence conditions, then you are liable to be returned to serve the remainder of your sentence.
Or perhaps a fixed term of that sentence.
Yeah, might not serve all of it, might you?
No. So that's where we stood, and it was all relatively simple. And then along came the Offender Rehabilitation Act of 2014, what I will call one of those sort of stealth bomber pieces of legislation, bit like the Courts Act 2003. Why? Well, because it went under the radar of most criminal practitioners. And what did that give us? Well, it gave us this. Anyone, I'm talking adult offenders, 18 or over, anyone given a custodial sentence of 2 days or longer would effectively serve half the sentence and would be licensed for the remaining half of the sentence, and then would be subject to post-sentence supervision if the license didn't add up to 12 months following release. Are you following this, Clive?
Give me an example, Colin. Give me some numbers and figures around that.
Imagine your client in the local magistrate's court, guilty plea, driving whilst disqualified. Got a bad record for driving whilst disqualified, entitled to his third off, credit for a timely guilty plea, 6 months goes down to 4. Serve 2, be licensed for 2, be subject to post-sentence supervision for 10 months. Why? Because the period of license and post-sentence supervision would add up to 12 months following his release.
So you almost have to ignore the sentence that he served, although that helps you to calculate the other half.
Let me give you another one. Crown Court. Crown Court. Imagine the client gets, 18 months at the Crown Court. Will serve 9. Would be licensed for 9. And then would be subject to post-sentence supervision for 3 months. 9 plus 3 equals 12. Your license and your post-sentence supervision to add up to 12 months following release. Now, Clive, you with your O-level maths, you've worked out immediately that anyone given a sentence of 2 years or more prior to the amendments, anyone given a sentence of 2 years or more, there would be no post-sentence supervision. Why? Well, because think about it, the whole of that 12-month following release would be eaten up by your license. So no, anyone given 2 years or more, they'd be subject to their license of 12 months or more or whatever, and there would be no post-sentence supervision. For those people, of course, subject to post-sentence supervision and license, as you say, they could breach the terms of their license, in which case they might find themselves on a fixed-term recall of 14 days or 28 days. Or they might breach the terms of their post-sentence supervision, in which case they're back in court, where the court could impose upon them a fine not exceeding £1,000, or something called a supervision default order, which would contain effectively community service, curfew, that sort of thing.
Yeah.
And no doubt solicitors appearing in the magistrate's court were in the position of having to represent people in breach of their supervision, whereby they were given whatever, a supervision default order perhaps, and then further, they were representing people in breach of the terms of their supervision default order. And on it would go.
Yep.
So that's where we were. Seriously, that's where we were from 2014 onwards. And you've got to keep that in your mind, because that's just a layer on top of the new stuff that we've been given fairly recently. So let's deal with the new stuff in terms of the old 50% going down to 40%. We know, don't we? Was it September and October of last year that there was a wholesale release of people at the 40% stage of their sentence rather than the 50% stage? Although it wasn't reported in the press, it occurred to me that these were the people, of course, who had not been released even earlier than that, subject to the home detention curfew scheme. These were people who truly served the determinate part of their sentence. It just so happened that determinate part went down from 50% to 40%.
Yeah, I'd agree with that.
Good news for them, having to serve 40% of the sentence rather than 50%. And I've given people a link to the relevant statutory instrument whereby there was that reduction from 50% to 40%. It's statutory instrument 2024 number 844.
We should say at this point, Colin, that in each of our episodes, we will have show notes. So if you are walking the dog at the moment or driving the car or doing something else where your hands are not available to write anything down, then no, you'll simply be able to download the show notes and there will be a link to all the documents that we mentioned during all our podcasts.
So with this statutory instrument 2024 number 844, as we know, there's a schedule in that particular statutory instrument. And the purport of that schedule, of course, is that if you're sentenced for an offence contained on that schedule, you don't get the benefit of the 50% going down to 40%. You will still have to serve 50% of your sentence.
Give us a flavour, Colin. What sort of offences were exempted from that list then, going down from 50 to 40? Were they violent sexual offences?
I would have thought they're offences of a violent sexual nature, offences against...
Going back to that list of people with whom you said you'd be happy to live alongside earlier, Colin.
I think they were the people I said I would not be happy to live
Yes, those are the ones. Did you write the list by any chance, Colin?
Well, it wouldn't take long, would it, to compile a list of the
Not
people
really.
we don't want to live alongside in the community?
Exactly, yeah.
So there we are, 50% down to 40%. So let's do the maths, shall we? Because of course it's quite beneficial if not only are you going to be released at the 40% stage, but you're also going to benefit from even earlier release under the home detention curfew scheme. So let me just mention that for a while, shall I? And the various amendments we've had to that. Now, we know it's discretionary, don't we? So we know you have to behave yourself in order to be eligible for early release. It's discretionary at the discretion of the governor. And while one can well understand why we have such a scheme, of course, no doubt it helps to maintain control and discipline in prisons. People have an incentive to behave themselves on the basis that they might have early release.
And that's, Colin, just to interpose, that's how Colin works more generally, isn't it? In the sense that there is this process. You know, you go in and you are on basic, as my clients always used to tell me, you'd be on the basic regime. And then if you kept your nose clean, quite literally for some people, and behaved yourself, etc., then you'd be on enhanced prisoner, wouldn't you? And you'd be entitled to certain things. Like sometimes I think you're able to wear your own clothes, or you'd have more visits, all those sorts of things. So that's the way the prison system works, isn't it, in terms of discipline, in terms of incentives and privileges, etc. And this is just another one of those, isn't it, in terms of incentivizing people to behave themselves so that the governor might think, well, he's worthy or she's worthy of perhaps being released early under home detention and curfew, which is effectively an electronic tag, isn't it, Colin?
It is. It's effectively an electronic tag. Absolutely. So I can well understand that. But I don't know. Do you think there's something a little disingenuous about the executive saying, well, you know, whatever sentence you're given at the court, be it a magistrate's court or a Crown Court judge, you'll only actually have to serve 40% of that sentence, and you might be released even earlier under a tag? Because it seems to me that when the sentence is handed out by the judge, it might, as it were, seem quite a stern sentence to general members of the public, or to perhaps the family of the victim of the particular crime. But when you fashion in that, assuming it's not one of those excluded offences, he or she is going to be released once they've done 40% of that sentence, and then it becomes a sentence, does it not, of a much lower order?
Yeah, absolutely. As you say, I think victims of crime would be unhappy, to put it mildly, to find out that their offender or perpetrator might not actually serve what it was in court the judge said they should serve. That's a matter for Parliament, really, isn't it, and government to deal with in terms of the way that sentencing is communicated more broadly.
Yes, but I think it would be fair to say that the average member of the public would assume that if you were given something like, 30 months by a Crown Court judge, 2.5 years, that you would serve a substantial period of that 2.5 years, and you're nodding in agreement. Of course, the reality is, if you get out your slide rule, that dates me, doesn't it, Clive? Slide rule.
Is it sat next to your abacus, by any chance, Colin?
Gosh, I remember as a child being given a slide rule, and I thought, "Ooh, what sorcery is this? Hey, this will surely unlock the secrets of the universe." Well, it didn't, but it did help me with the old maths. So let's have an example then. 30 months. A sentence of 30 months has been imposed by the Crown Court judge. Taking down 30 months. 40% of 30 months, of course, becomes 12 months. Now, you're also entitled to a maximum benefit at present by way of early release, home detention curfew scheme, 6 months. So that 12 months, determinate part of the sentence, goes down to 6. You're effectively serving 6 months of a 30-month sentence handed down by the Crown Court judge. I know you've got O-level maths, Clive, and I know you know that 6 months as a percentage of 30, it ain't 40%, it's 20%. It's a fifth.
Yeah.
And the reality of the situation is that anyone given a sentence of 30 months or fewer, 30 months or less, if they also benefit from early release under the home detention curfew scheme, you can do the maths. It works for any sentence of 30 months or less. If you get the full benefit of early release, you're doing a fifth of your sentence rather than 40%. That's the position we have at the moment. And in relation to early release, once upon a time, your early release maximum benefit was capped at 135 days. Well, again, you will find that you've been given a link to a statutory instrument whereby that 135 days went up to effectively 6 months, 180 days. The maximum benefit that you can accrue at present from early release, 180 days. Which is near enough 6 months, is it not? If you divide 365 by 2, you get to 182.5. So you're benefiting there by the best part of 6 months.
Yep.
They've also, and you've got a link to Statutory Instrument 2024 number 755, they've also abolished what's called the 4-year rule.
Yeah.
And before the abolition of the 4-year rule, you were only entitled to be entered for the scheme if your sentence was between effectively 3 months and 48 months. Well, the 4-year rule has now gone. It matters not how long your sentence. It could be 5 years. It could be 6 years.
And we've had that 4-year rule comes and goes, doesn't it, Colin? In the sense that I remember very vividly when I first started in practice some 20 or so years ago, that when you went down to see the client, that the client was desperate to get a sentence of under 4 years rather than 4 years or more, because the old rule used to be that if you got less or fewer than 4 years, then you would serve half, but if you got 4 years or more, then you had to serve 2/3. So, clients were at pains to try and squeeze in a 3-year and 9-month sentence, for example. And that was always the easy way, and even defendants, clients that, before you even went to see them in the cells, they knew about that. They'd come and say to you without you even saying anything, am I going to get under or over 4 years? Because they were worried about how long they were going to have to serve. That did the rounds on the wings in prison. You don't want to get 4 years or more because you'll be in here for 2/3 of it.
Let's just clarify that point now, shall we? Because you have raised it. So the position is that in relation to your 50% going down to 40%, doesn't apply to anyone who would not otherwise have been eligible for release at the 50% stage. And as you say, Clive, there are more and more prisoners for whom release is now not possible until they've done 2/3 of their sentence. Well, for those people, they're still going to have to do their 2/3. They won't benefit from the 50% going down to 40%. So just quickly compiling a list of those people who have to do 2/3. And it's a fairly complicated list. It used to be much simpler, but as we all know, the law is far more complicated now. It used to consist of offenders who were sentenced under the dangerous offender provisions of the Criminal Justice Act of 2003. Those people having to serve 2/3 of the determinate part of their sentence before being eligible to apply for parole. No change there, no change at all.
Yeah.
Ditto for what we call offenders of particular concern.
Yeah.
These people also have to do 2/3 of their sentence, and then they become eligible to apply to the parole board for release at the 2/3 stage. That much was simple. The waters began to muddy somewhat with effect from the 1st of April 2020, when the law was amended, whereby adult offenders, those people 18 or over, given a term of 7 years or more for an offence within Schedule 15 of the Criminal Justice Act 2003, Part 1 or Part 2, in other words, those specified offences of violence and specified sexual offence that would otherwise carry life. So, essentially, a good example, if you got 7 years or more for a rape offence, a determinate sentence of 7 years or more, and you were an adult, you would have to serve 2/3 of that particular sentence. Don't get me wrong, you wouldn't have to apply to the parole board for release, but you would have to do 2/3 of your sentence. Ditto for someone given 7 years or more for grievous bodily harm with intent. Again, an offence of violence carrying life. And this is still true. This is still the law. Adult offenders given 7 years or more for a sexual offence or an offence of violence that potentially carries life would have to do 2/3 of their particular sentence.
This podcast is recorded on behalf of Legal Eagle Training. You can find us at legal-eagle-training.com.
Legal Eagle Training has nearly 100 one-hour recordings already on the website, and most of which come complete with notes. We've been doing this now since June 2020 on topics as diverse as
the Magistrates Court, including the Youth Court,
life at the police station,
road traffic,
advocacy, Magistrates Court advocacy, Crown Court advocacy,
criminal law updates, including case law and the latest legislation,
and the subject we both know most dear to your hearts, the billing of criminal legal aid.
The website is constantly being updated with new courses on the latest topics. We add 2 further presentations on the website per month. Each presentation lasts an hour and comes with a full set of notes. Do visit the website, as there's going to be something there that appeals to you as someone involved in criminal law.
Right, back to the episode.
And I'll just interject there, Colin. You may remember the name of the case off the top of your head, but I can't. But back in 2020, there was a case that went to the Court of Appeal because there was a group of defendants whose case was adjourned from March 2020 due to COVID until April 2020, which meant that had they have been sentenced at the original sentence date, they would have had to have served half their sentence. But because of that adjournment, they tipped over that time, the 1st of April, as you've mentioned, and it meant they had to serve 2/3 instead of half. They went to the Court of Appeal, and the Court of Appeal said, nothing we can do about it, it's a matter for Parliament, when they say, how long you will serve. We simply hand out the sentences. Parliament dictates how long you actually serve afterwards. I did have some sympathy for them, but yeah, you'd be sat there counting the extra days you were doing, wouldn't you? Counting the days anyway, but counting the extra days you were doing, thinking, for goodness sake, had I just been sentenced a week or two earlier, things could have been rather different.
I think the Court of Appeal have said more than once it is not for the judge to factor into the sentence the release date of the particular offender. That's a matter for the executive. That's a matter for the governor.
Yeah.
So that's where we stood on the 1st of April 2020. We then, of course, had the Police Crime Sentencing and Courts Act of 2022, which amended things slightly in relation to those people having to serve 2/3. The position changed somewhat in that 7 years for an adult went down to 4 years. The position being that if you're now as an adult given a sentence of 4 years or more for one of those specified offences of a sexual nature that potentially carries life, you have to do 2/3 of your 4 years rather than half.
Yeah.
The 7-year rule still applies, of course, for all violent offences that potentially carry life. But the 4-year rule doesn't. The 4-year rule, could you make it any more complicated if you tried? The 4-year rule, of course, apropos offences of violence, only applies to those 3 offences of violence that are mentioned in section 130, subsection 7 of the Police Crime Sentencing and Courts Act of 2022. So we're talking about manslaughter, we're talking about soliciting murder, and we're talking about wounding with intent to do grievous bodily harm. So if you're an adult and you get 4 years or more, but less than 7 years, you will do effectively 2/3 apropos one of those offences. But if you get 7 years or more for a violent offence or a sexual offence which potentially carries life, you will do 2/3.
Yeah.
Why they've sought to limit it for those 3 offences, if it's an offence of violence and your sentence is for 4 years but less than 7, I know not.
No.
They've also, for good measure, thrown youths into the mix.
No. What have they done with them, Colin?
If you look at section 130, subsection 7, again, of the Police Crime Sentencing and Courts Act of 2022, if you're a youth, someone aged 17 down to 10, effectively, and you're given a sentence of detention at the Crown Court under section 250 of the Sentencing Act 2020 for a sexual offence that would otherwise carry life, or one of those 3 violent offences that I've just mentioned. But for youths, you have to be given a sentence of 7 years or more, not 4 years or more. So youths are included now, but it has to be a sentence of 7 years or more.
It's a hefty sentence as a youth, isn't it, to get 7?
Well, yes, it is a hefty sentence, absolutely. And I don't have the feeling that youths, bless them, are being left behind somewhat, yeah, in terms of the amount of time they have to serve. And of course, it will be even worse after, the 3rd of June this year. Again, I've put the relevant statutory instrument in, the link to the relevant statutory instrument. This is statutory instrument 2024, number 1331. But just to finish, before I look at this statutory instrument, just to finish on the topic, that was just really, Clive, a current list of those people who have to serve 2/3 of their sentence, whereby the reduction from 50% to 40% is of no use to them whatsoever. They're ineligible because they have to do 2/3.
So it seems that we're going in opposite directions almost, Colin, isn't it? Depending what offence you're sentenced for, you're going to serve, on the one hand, you're going to serve less and less. Whereas if you're sentenced for something serious and you get quite long, you're going to be inside for more and more. So there's a gulf, isn't there, depending on what the nature of your offending is, in terms of how much you're actually going to serve inside or out.
Yes. And of course, the position will change again as regards early release under the Home Detention Curfew Scheme. It's statutory instrument there 2024, number 1331, whereby your benefit, if you're given the maximum benefit of early release, will go from 6 months to 12 months. Now that will be a great benefit, I would have thought, to people given long sentences at the Crown Court. I gave an example earlier, didn't I, of the person given a 30-month sentence, 2.5 years. Well, let's just do the maths, shall we, of the person at the Crown Court who's now being given a sentence by the Crown Court judge of 60 months. Yeah, that's 5 years. Well, 40% of 60 months is 24 months. Now, when the person will be entitled to early release, they'll get 12 months off the 24 months. So they're now doing 12 months of a 5-year sentence. They're doing 1 year. They're doing 1 year of a 5-year sentence, assuming they're not on the schedule of people, as it were, who will still have to do their 50% rather than 40%. And assuming they get the whole entitlement of the 12 months by way of early release. That entitlement to 12 months coming into force 3rd of June this year, 2025. You get 5 years, you behave, you're not on the schedule, you'll do 1 year.
Yeah, that's staggering, isn't it?
And again, the maths are the same if you think about it. In that once 6 months by way of early release goes up to 12 months, the maths are that anyone given a sentence of 5 years or less will effectively end up serving 20% of their sentence, 1/5.
Yep.
Now, you compare and contrast that with the poor juvenile. He or she only has to get a 24-month detention and training order in order to be locked up for a period of 12 months. Quite different to the adult offender who's looking at a sentence of something in a term of 5 years.
Yeah. Father and son, one gets 24-month detention training, or the other gets 5 years. And as you say, they both end up spending the same time inside, don't they?
Yeah. And of course, the 20% rule only works at the moment, remember. The maths only work at the moment if you're given a sentence of 30 months or fewer, because, of course, the maximum benefit you can obtain is, at the moment, 6 months. And, of course, the sentence will rise in terms of the maximum benefit being 12 months. That sentence will rise whereby you'll get a sentence, if you do, of 60 months or less, and assuming you get your whole 12 months early release, you'll do 20%. Of course, the higher your sentence, the less you will benefit, because you still have to do a half of the determinate part of your sentence before you can be released early. Let me give you a simple example. Imagine you get, 120 months at the Crown Court. That is a 10-year sentence. Firstly, you have to work out what's 40% of 10 years. Well, that's 48 months. That's effectively 4 years. So what's your maximum benefit? Well, your maximum benefit is 1 year, 12 months. So you take, of course, 1 year from the 4 years and you end up with a 3-year sentence. Well, we know, don't we? A 3-year sentence is more than 20% of a 10-year sentence. But that's because you cannot benefit by more than 12 months, or won't be able to benefit by more than 12 months by way of early release for those people effectively sentenced after the 3rd of June this year. And just dealing with home detention curfew scheme, if I may, for a moment, giving you a link to a very important document, the revised home detention curfew scheme, This document was revised in June 2024 to coincide with all the changes that have been recently brought about. And it's fair to say that the presumption is that if you can enter the scheme, you should enter the scheme. The executive wants people to be released early. But of course, if you look at that particular document, you will see that certain people are excluded from entering the scheme. They're excluded by statute. Yeah. And the top of that list of people excluded by statute is, would you believe, those people who have to serve 2/3 of their sentence. So it really is bad news for you if you have to serve 2/3. You don't get the benefit of 50% down to 40%, nor can you enter the early release scheme, the home detention curfew scheme. Nor can you enter the scheme if you're a sex offender forced to register as a sex offender, which is fair enough. Nor can you enter the scheme if you're serving a sentence for being in breach of the requirements of your community order, where the breach was breach of your curfew.
So we don't trust you quite.
Exactly. Yep. You've shown yourself to be a person who cannot be trusted to abide by a curfew.
That's important advice to be giving your client, isn't it, Colin? Yeah. That's important advice as an advocate. To say, look, you've got a curfew, but do you know what? If you come back here and breach it, you'll go inside and you won't be allowed out on a curfew because you breached your curfew. So if you're going to breach any of this, don't breach your curfew, because you're going to get a double whammy. One, you'll go back inside until you won't be able to get out early.
Never was it quite so important to make sure you comply with your community sentences, particularly if one of the requirements of that community sentence is that you abide by a curfew.
Yep.
So there's a whole list of people who are excluded by statute from entering the early release scheme. And then, of course, there are people for whom there is a presumption of ineligibility. It's all set out in the document, which I found was a very interesting read. But as we know, Clive, I don't get out very much.
I've never known someone to be so enthusiastic about statutory instruments, Colin.
Absolutely. What? When the Sentencing Act 2020 came out and was introduced in its entirety with Royalists said, I thought it was Christmas Day and my birthday rolled into one. Hey, the joy of 420 sections, and when you'd read those, you'd got 29 schedules to look forward to.
There you go.
Meanwhile, back at these people who are presumed ineligible for entering the scheme, there's a whole host of them, of course, and anyone with a history of sexual offences, but who is not required to register as a sex offender. These people aren't excluded by statute, but there is a presumption whereby they ought not to be permitted to enter the scheme for early release. And with that presumption, the document says that they may submit representations to the governor to the effect that they are an exceptional case whereby they should be permitted entry to the scheme.
Yeah, and just to be clear to people listening, that if you are required to register as a sex offender in certain circumstances, that will mean you need to register for the rest of your life. In other circumstances, depending on how long you get, so we've just been talking about what sentence you receive dictates how long you'll necessarily need to serve and for what offence you've been convicted of. It's the same in relation to sexual offences, isn't it, Colin? Depending how long you are sentenced to in terms of the custodial element of the offence, dictates how long you need to register for. So it might be that in your early 20s you commit a sexual offence and you're required to register for 7 years maybe because you received 6 months or more, and then it might be that some 20 years later you're inside for a bit of burglary, and as you say, in those circumstances that person wouldn't be registering anymore under the sex offenders provisions. However, there would be that presumption, and it would be for them to displace that presumption before the governor and say, look, I'm actually a good bet for home detention and curfew, despite that conviction on my record.
Yeah, absolutely. And of course, none of what we've said at all during this podcast will affect those people who are effectively given life, be it mandatory life or discretionary life. Because we know, don't we, that those people are given a tariff sentence, every day of which must be served. And when they've done their tariff sentence, they can apply to the parole board for release. And if they are released, they'll be subject to life license. And if they're not released, they'll be entitled to an annual review before the parole board in order to assess whether or not they should ever be released.
Yeah. I don't know what the latest figures are, Colin, but I think the overwhelming majority of people who receive a life sentence are not released at their first review. It's very unusual for somebody to be released on their first review.
Yes.
Yeah.
So how can we sum it up? We can sum it up, can't we, by saying that the sentence you're given is not necessarily the sentence you're going to serve. Certainly, the 50% down to 40% is very beneficial. Clients, I suspect, will know quicker than their lawyers, what their release at the 40% stage is. And of course, if they're eligible for even earlier release under the home detention curfew scheme, clients will also be able to calculate, well, my maximum benefit is 12 months. So that could be knocked off the determinate part of the sentence. Bearing in mind, you must always serve a half of the determinate part of your sentence before being released under the home detention curfew scheme. That's why the maths work. If the determinate part of your sentence that you would serve ends up at being 12 months, but you can be released 6 months earlier because at 6 months you've done half of the determinate part of your sentence. That's why it will work. The maths will work if the percentage you have to serve happens to be 24 months, but you're eligible for early release under the scheme after 12 months, because after 12 months, you will have served a half of the determinate part of your sentence. Remembering that rule is very important in working out how long a client will actually have to serve.
Yeah. I think once prisoners are, once your client is taken from court to prison, usually within the first week or so, they are given a sentence plan. The prison will do the maths that you've just been describing, and then that will be given to your client. Because I often had that question from my clients, and it was a classic lawyer's answer, wasn't it? How long will I serve? And it will always be because, well, it depends, it depends on whether the governor likes you or not. It will depend what sentence, what previous conviction. You've got all those sorts of things, and it's there's a lot going on in the aftermath of a sentence when you're a court, and it's impossible to advise your clients on everything. But one thing that I felt put their minds at rest just a tiny bit was just to explain to them, look, in the first week or so, you will get your sentence plan and you'll know the answers to all of this in terms of when you might first be eligible for release and all those sorts of things. And so they had that to hold on to, at least in the first week, in terms of getting an idea of how long they would be inside or how long they would be out.
Yes, but I'd say this, Clive, on a sort of more serious note. If you're a practicing criminal lawyer, you really need to have a working knowledge of the offences on that schedule contained in Statutory Instrument 2024 number 844, whereby you just simply don't get the benefit of 40% because it's an offence on that schedule. So you need to know that. And you also should have a working knowledge of the revised home detention curfew scheme and how it works, so you'll know immediately which of your clients are excluded by statute from even entering the scheme, and which clients have a presumption of ineligibility whereby they have to make out a case concerning an exceptional case whereby they should enter the scheme. I don't wish to be critical of criminal practitioners. I speak from the benefit of being retired. I've got the time and the inclination to read all of this, but there's an awful lot being thrown at criminal practitioners, and it must be very difficult to keep up with all of this.
Yeah, absolutely, Colin. I agree. I don't envy those still at the coalface having to deal with all these issues on a daily basis.
No, I think it's fair to say that generally, the law used to be simpler. It used to be simpler when I was in practice. It seems that every document, every piece of legislation And every statutory instrument is a layer on top that people have to take into account. Remember, you must factor into all of this, of course, the Offender Rehabilitation Act of 2014 and licence and post-sentence supervision. None of that's gone away here. That's just a layer on top.
Colin, was it Lord Wolfe some years ago now, former Lord Chief Justice, who described the sentencing provisions as a labyrinth?
Yes, they're fond of that word in the Court of Appeal. They said the other day that certain sections of the Sentencing Code 2020 were labyrinthine in their complexity.
Quite. And the Sentencing Code was supposed to decode all of that, wasn't it, and help us to make this all a lot more straightforward.
Well, I think they missed a trick, didn't they, on the Sentencing Code? They could have used this as an opportunity to simplify the law, but they didn't. They used it as an opportunity to codify the law. They said, look, we brought all of these various statutes into one easy read. Yeah, one easy read. 420 sections and 29 schedules.
Yeah, so it's far easier to find all these complicated sections now than it ever was before. Well, it's a start, I suppose, isn't it, Colin?
Indeed. You won't understand it, of course, but you will be able to find it.
Exactly. There we go, Colin. On that bombshell.
We could go on, but we've got to stop, haven't we? Look, I do hope that that people watching this have got something out of it. It is essentially aimed, obviously, at criminal practitioners. There's a strong thread of criminal law running through all of these podcasts, but who knows? And people who are not necessarily criminal practitioners, but are interested in how the criminal law works, they may find these podcasts of interest as well. Time will tell.
It will. Thanks, Colin.
Cheers, Clive. Well, thank you for tuning in to this particular edition of the Legal Eagle podcast. We do hope that you've enjoyed it. You can find further episodes on our website, legal-eagle-training.com. On behalf of myself and Clive, thank you. Say goodbye, Clive.
Goodbye, Clive.